colleagues, greetings to everyone. The anti-corruption system in Ukraine is one of the key mechanisms for ensuring justice and fighting corruption. But how effective and independent are the anti-corruption bodies today? Do they truly fulfill their mission properly, or does the system require serious changes? These questions concern not only the public, but also the legal community. Recently, Transparency International published the Corruption Perceptions Index for 2024, where Ukraine lost 1 point, scoring 35 out of a possible 100 and ranked 105th among 180 countries. -1 is not yet a collapse, but it is already a worrying signal of stagnation. This means that the reforms are either stalling or not producing the desired effect. So the key question is, what is being done wrong? The legal newspaper, together with the team from the law firm AVER LEX, conducted a study on the assessment of the effectiveness and independence of anti-corruption bodies, the opinion of lawyers on these bodies. Today we will discuss the results with those who work with these processes daily, representatives of the National Anti-Corruption Bureau of Ukraine, the Specialized, Anti-Corruption Prosecutor's Office, the High Anti-Corruption Court, and a representative of the legal profession who defends the rights of her clients in corruption cases. The survey showed that the legal community does recognize the importance of anti-corruption bodies, but has doubts about their effectiveness and independence. A total of 178 respondents participated in this survey, among whom 82% are lawyers with significant experience in the field of anti-corruption defense. This ranges from 8 to over 15 years. These are representatives of both large and small law firms and self-employed lawyers from various regions of Ukraine. This study was divided into 2 sections, general and professional. Therefore, Olga and I propose to consider a couple of extremely important questions today, which we believe concern everyone from both the general and professional sections. So I will ask to display the first slide. Is the presumption of innocence upheld in anti-corruption cases? What do we see? Over 86 respondents believe that the principle of the presumption of innocence is still violated in corruption cases. We have questions for the National Anti-Corruption Bureau of Ukraine. Mr. Oleksandr, tell us, does the NABU consider the risk of violating the presumption of innocence when disclosing case details?
In its work, the National Anti-Corruption Bureau of Ukraine primarily considers the balance of interests, since the disclosure of pretrial investigation data is provided by law. At the same time, the public has the right to know how certain corruption cases are being investigated, because this is one of the elements of transparency in the work of the National Anti-Corruption Bureau. At the same time, when we disclose or provide certain information, it is done through a certain level of control. Information is provided by the National Anti-Corruption Bureau in agreement with the Specialized Anti-Corruption Prosecutor's Office. When providing this information, certain things are always taken into account. That is, the fact is provided, the person who is being discussed is referred to as a suspect. The person is never accused, nor is it said that this is the person who committed the crime. It is indicated that this person is a suspect to whom a certain fact is attributed. Information of a personal or private nature is never disclosed. The National Anti-Corruption Bureau facilitates the dissemination of information moot to the public, which the public primarily expects from the National Anti-Corruption Bureau. And here, the key point is the balance between the information that is provided and the information that is requested, in order not to create any preconceived notions, including in the court, as you may notice. When information is provided by the National Anti-Corruption Bureau, the main points and sometimes the materials of covert investigative actions are provided only after preventive measures are chosen. This is done specifically during their consideration, in no way to influence the High Anti-Corruption Court.
Thank you very much for this thought. We will also discuss the influence of public organizations on your body during the process. Mr. Andrii, as a representative of the Specialized Anti-Corruption Prosecutor's Office, tell us, how do you find the balance between public demand and the rights of the accused?
I would like to thank you for the invitation. Indeed, important events and important discussions, they contribute to improving the work of everyone. Regarding your question, I would like to note that indeed for a prosecutor, this is a complex issue. Finding this balance between public interest and between the rights of the accused. Therefore, as we deal with corruption crimes, and there are global studies that indicate that corruption crimes always represent a public interest. Since corruption, in one way or another, affects everyone, and the higher the level of corruption, the more it impacts the interests of citizens. And accordingly, there is always interest in such cases. Now, we are talking more about the fact that the prosecutor supports not a state prosecution in court, but a public one. And here, the names matter. This means, that we are still reorienting towards the idea that prosecutors are representatives of society, not the state apparatus. And on the other hand, there are the rights of the participants in the process. And so, as a prosecutor, I can express my point of view and can, in principle, speak for my colleagues. I believe that everyone also supports it, that in our institution, all prosecutors perceive our work primarily through the lens of ensuring a fair trial. And a fair trial is not just about a fair decision, but rather we emphasize that the procedure itself is more important. Even a fair decision made through an unfair procedure will not be accepted by anyone. Neither a guilty verdict nor an acquittal will be accepted. And a fair procedure ensures the presumption of innocence, that there is respect for the right to defense, equality of the participants in the process is ensured, and the defense is given the opportunity to fully exercise their rights. And we adhere to this and strive to meet the highest standards. Specifically, regarding ensuring the presumption of innocence and interaction, with the media, we have certain internal policies, both within the organization and joint memorandums signed with the National Anti-Corruption Bureau. And in this direction, measures are taken by both the institution's leadership and each prosecutor to ensure these guarantees. And I hope we are succeeding in this, and you can see it in the media through our publications.
Thank you for the answer. Today on our podcast, we have a representative of the legal profession who defends clients in corruption cases daily. Olga, how is it in your practice? What do you see?
Is the presumption of innocence often violated? Well, I want to say that the trend for decades, it was not a matter of action, but of words. Not words, but a post on Facebook. And now, in the last 2 to 3 years, it's not just a post on Facebook, but a message in a Telegram channel announcing that a criminal organization, a group of people, or an individual has been exposed. Photos are immediately posted. For some reason, well, in NABU, SAP, I'll say this complementarily, other agencies don't do this for some reason in underwear. And there is no announcement, unless it's laid out on the table or floor in neat rows for maximum visual effect. Cash, funds, that's all. As soon as there are cash funds and someone is detained somewhere, the announcement is almost ready. So what I want to say, in principle, I want to commend the NABU and SAP press services because they work as correctly and professionally as possible. If you open Facebook pages or Telegram channels, you will see that in any press service announcement, there is always a note. It's even called a disclaimer stating that according to Part 1 of Article 62 of the Constitution, every person is considered innocent until their guilt is established in a lawful manner. So the young professionals are doing a great job. But those who don't make mistakes are those who don't work. There are various interesting cases. This is the good part, that they work professionally, but it's interesting. Here I want to be, like today, I'll be so generous with compliments that my colleagues will strike me off the list of the Bar Association. And on a positive note, here's a compliment towards in the direction of the facts, because in her first practice, I saw something in October 2023. The High Anti-Corruption Court issued a ruling, a separate ruling, which established a violation of the presumption of innocence by one of the NABU detectives, because in a Telegram channel during a certain segment, the detective presented the factual circumstances of the case. In such a way, formulated the evidence and specifically named the case, which directly provided context. The conversations and categorical judgments gave grounds for an outside observer to believe that the person was guilty of committing the crime. And the defense, as I understand, filed a corresponding motion. And for the first time in my many years of practice, for the first time when the court issued such a ruling on the violation of the presumption of innocence and sent it to the director of the NBU for response. I don't know how the director reacted. Maybe Oleksandr will tell us how it is with them. This happens in practice, but it was the first case in my history. One more remark. When we conducted the research, some respondents, practicing lawyer colleagues, were a bit uncomplimentary towards the HACC, but there must be a balance. Noted that the HACC considers cases based on the presumption of guilt, the opinion of the respondents, but I like everything to end on a positive note. We are talking about the actual circumstances, about how colleagues react on a positive note. I'll say this. In the 5 years of the HACC's activity, 240 verdicts have been delivered. If you look at it, 23 or 24 of those verdicts are acquittals. In percentage terms, that's 10%. Well, that's a very impressive result. Anyone who practices in criminal cases knows that throughout the entire period of activity, the number of acquittals was 0.2%. And here it's as much as 10%. So to end on a positive note, yes, indeed. The High Anti-Corruption Court forces all of us, including the prosecution, the pretrial investigation body, and the defense, to work hard, stay resourceful, and properly present our positions. Each side, therefore, perhaps colleagues get such an impression. Maybe sometimes the processes are quite tough. But I will say from my side that if you are a professional, if you are well-versed, then everything will be fine for you. And 10% is a good result, I believe.
Mr. Andrii, do you agree with Olga's statements about the convictions and the statistics she provided?
The statistics are relative. They match mine, prepared by our press service for me. Also, the statistics show that as of December, we have issued 232 verdicts, of which 25 are acquittals. That is indeed in comparison with the number of verdicts, these categories of cases. Well, firstly, before the work of VAX began, there was no talk about such a number of verdicts, neither acquittals nor convictions. That is, these cases were considered for years in district courts. And to say that there was some positive or negative statistic, well, it's almost impossible. There were just a few of these verdicts. Currently, we must indeed state that VAX is not focused on imprisonments, as they were preparing society. That is, we will probably return today in our dialogue to how society perceives, how the media reacts, but remember the year 2019. Now VAX will start working, and by December everyone will be imprisoned. Well, okay, not by December, now somewhere by March. Society, we understand, was prepared for a massive, just corrupt officials will be sent in freight cars somewhere to an artificially created Siberia to cut down forests. But the reality is that we have to orient ourselves towards the European Convention on Human Rights and the decisions of the ECHR. We understand that we can demonstrate some kind of punitive, super effective practice today, but ultimately, for such decisions, which will be neither legal nor fair, the state of Ukraine will be held accountable. We must remember those same decisions of the ICAR. We can now satisfy some public demand, but time will pass. In 5-10 years, the state, using taxpayers' money from that same society, will compensate for this. Therefore, we try to issue verdicts that are as much as possible not what society needs, but those that align with the interests of this society, the interests of the state.
I would like to ask a clarifying question here. Do you believe that statements from anti-corruption bodies can exert pressure on the court?
Well, you can't say that. Someone who publishes news or some appeals, perhaps in other areas of activity, this could be perceived as pressure. For the court, pressure is when actions are taken that can truly sway the court to make a certain decision, not the one that should be made as a result of the adversarial process. At the moment, I cannot say that there are any such actions from law enforcement agencies or from the legal profession. Such manifestations are widespread, or at least in large volumes. Yes, there will always be a party that disagrees with the court's decision. When the court satisfies the prosecution's side, lawyers disagree. Lawyers may criticize. Similarly, law enforcement agencies, the prosecution and the prosecutor can also criticize. But this is not pressure. This is within the framework of discussion. This is within the framework of this legal procedure. We need to discuss this. We need to discuss legal positions. More often, in my opinion, the pressure or attempt at pressure may not be directly intentional pressure, but it can come from certain media outlets rather than from the participants in the process.
We will talk about this now. I asked to open the second slide. Can we talk about pressure on anti-corruption bodies from public organizations or activists? And how does this affect the objectivity of investigations? What do we see in our statistics? Survey? What do the respondents' comments indicate about the fact that public organizations can not only assist anti-corruption bodies, but also sometimes manipulate information and exert pressure on the decision-making process? The influence of public organizations is assessed as high by over 23%. Yes, respondents believe it is very high at 5.45%, moderate at 31.82%, and 13%, a total of 64%, believe that this influence is low or very low. Colleagues, have there been instances where information leaks from public organizations significantly influenced the course of events?
Well, as always, it's a matter of balancing interests. The fact is that, on one hand, public organizations, investigators, the media, they are good, reliable partners, primarily for the pretrial investigation body, because they uncover various interesting facts, provide intriguing information that can later be used by us for work. At the same time, there is another side to the coin. It consists of such things. First, for example, the pretrial investigation body is investigating something. There are already established facts, and perhaps some covert investigative actions are being carried out as part of the investigation. This is much faster than qualitative collection of evidence. During this work, when suddenly a report comes out or some corruption component is highlighted, it can significantly affect the work of detectives directly during the collection of evidence.
And are you referring to a leak of information right now?
The thing is, if, for example, something is known to law enforcement, it might also be known to journalists. Or at some point, someone might inform someone about something. So it's not about a leak right now. It's about, I would say, effective competition, because investigative journalists sometimes do similar work to detectives. They also search for information, uncover where there are any corrupt deals, and write about it. Sometimes this helps law enforcement, sometimes it can slightly hinder, because if suddenly the investigative body is not yet ready to conduct any public investigative actions, it can become supercritical. An expose article where all participants in the commission of a criminal offense are listed, places where evidence might be collected, premises where some meetings took place. What do the participants in the criminal scheme do? They destroy all physical evidence that can be destroyed. They take measures to minimize their losses, and sometimes even, as we often document in our investigations, they start working out possible defense strategies, and this can hinder the investigation. But this is probably natural processes. It's just a consequence of having a very active society, both in terms of public organizations and investigators. And we simply consider these moments as probable. Regarding, as you say, the information leak, let's say it's quite a specific story. Sometimes such things happen. At the same time, real obstacles. At least I can't speak for the entire Anti-Corruption Bureau, but more for my unit, for those I work with more closely. It didn't hinder us. Even if some facts surfaced somewhere, then we used and operated in such a way that we sometimes obtained even more evidence than we could have at the planned moment.
So the journalists did work for you?
No. Let's say there are actually significantly more journalists than detectives. There are a little over 200 detectives who perform absolutely all the work, both investigative and detective. They drive around and deliver documents. The community of journalists is much broader, and they have the ability to concentrate on certain elements better. It is also important to say that a journalistic piece, even a good one, that resonates with people and helps them form a certain opinion about a person, is not an investigation at all. Because when we go to the High Anti-Corruption Court, we first go to the prosecutor, who is our first censor of our documents. They study them very carefully and look at what evidence we have brought, how we have processed, documented, and formulated everything. Next, we have the High Anti-Corruption Court, and when we go there, the level of requirements, even for the simplest request for temporary access to obtain some documents, to conduct a search or covert investigative actions is several times higher than the requirements in district courts. The thing is, I once worked in the police force, so I have something to compare it to. And therefore, our work requires much more time and thoroughness than the work of our colleagues. Sometimes this is a hindrance, but as of today, we have already taken this trend into account. And in most cases, even if such information comes out, many of our subjects, they do not always respond to journalistic investigations. That is, some react while others remain indifferent. For some, it's enough to find out that they were mentioned somewhere, and sometimes we even have the opportunity to record how people discuss it. And they laugh about something being written about them, saying, no one will catch us anyway. But sometimes we refute this thesis. Regarding pressure, currently, indeed, a situation has developed in Ukraine, and it's objective that public organizations have influence. There are so-called opinion leaders, meaning those who, when they talk about something, people listen to them. And sometimes in society, there may be an impression that this, I am speaking specifically in the context of the National Bureau, that this influences us. Speaking about myself personally and the team I lead, as well as many people I work with, I can state that when we make decisions, we primarily base them on the position of the law. That is what is most beneficial for the investigation. Sometimes we hear negative feedback from public organizations, but this does not really affect us in any way. That is, we do not have any mechanism where if we have fulfilled or not fulfilled someone's wish, someone would punish us for it. Our key result is achieving the goal of the criminal proceedings.
The legal profession doesn't really believe in this, I'll tell you honestly. But we can't expect that Oleksandr will just come out and say, yes, they demand from us, require report, we report to them, so they influence us.
You know, I'll tell you that, go ahead. And I'll tell you that, but go ahead. We often receive letters from well-known public organizations. Personally, about my decision, sometimes about the closure of criminal proceedings, or about not entering information into the Unified Register of Pretrial Investigations if we don't see grounds, or if we have investigated and realized that there are no grounds for further investigation, then we make procedural decisions. And I will say that during all the time I have been working at the National Anti-Corruption Bureau, it so happened that I joined it back in 2015 among the first 70 detectives. So, despite sometimes perhaps not entirely positive feedback from those who see it somehow differently, we proceed from the following. First, you can't please everyone. Act according to the law, and there will never be any complaints.
That's correct. That's a very correct message.
If you try to please someone, you will always lose. If you act according to the law and can explain your decision to anyone, ensuring it is motivated and justified, and you say you have a disagreement, can you provide an example? I can...
But I'm afraid you won't like it. Well, actually, since we are having a discussion, we can continue. I like what you're saying, Oleksandr. I truly believe that what you're saying is your truth, that the law should come first. If you are asking me for an example, I didn't suggest providing one. Unfortunately, I always thought that NABU and SAP were titans that were not susceptible to public pressure, to public opinion or any demands. But it so happened that in the course of defending one of my clients, I delved very deeply into the specifics of NABU's work, into the specifics of the demands of public organizations. I am being very correct here. I'm expressing my personal professional opinion, which I have observed when it comes to decisions of disciplinary commissions, for example, NABU, or certain materials and decisions procedural within the framework of the criminal proceedings investigated by SAP. A certain organization probably declares a person's guilt, states what decision NABU will make, what decision SAP will make, and that it will be made in a week. And a week later, NABU indeed makes such a decision, and SAP indeed acts accordingly. So my question is this a coincidence if, for example, within the framework of the disciplinary commission's review, an audio file is listened to where it is clearly stated that the anti-corruption officials demand this and we have to do that? Well, I was upset, honestly. I was upset, but I agree with you, in the part that you can't judge an institution based on some individuals. the institution. For me, the garden was also acquired. Remain leaders in terms of truly fighting corruption. And if we talk about fighting corruption, you are doing your professional work. But if we talk about influence, then in my personal opinion, and I say this within the bounds of correctness, it seems to me that neither NABU nor SAP should be subject to any external influence because it would harm the institution. By the way, I base my words and my opinion not only on, as I can already see, because now everyone around here will eat me alive, not only based on this personal example of mine, where I was genuinely upset. A very cool original interview with anti-corruption expert Drago Kos came out, where he very clearly laid out step by step how public opinion was formed and public institutions, how they influenced the anti-corruption hierarchy. And he states that unfortunately these certain public organizations have influence on NABU and SAP, which should not be the case. Therefore, I believe that I'm all for positivity.
I always end on a positive note.
I believe that it won't be like that, and that NABU and SAP will be independent and won't succumb manipulations, insinuations, pressure, and any demands from anti-corruption.
Regarding this, I can say the following. Clearly, this is an example. I cannot comment. When we talk about pretrial investigations, when we specifically talk about pretrial investigations, it's one thing. That there are certain moments when, well, we do have a democratic society. Today, we are experiencing a certain surge where, in fact, people can say almost anything they want, and various public organizations and the media, sometimes even quite harshly. But, well, these are the realities we live in. At the same time, when we talk about pre-trial investigations of top officials, current active ones, local self-government, I can tell you that in these specific situations, for example, personally, throughout my entire time working, I am not aware of anyone influencing someone to make a particular decision. Not only because we are so strong, but also because there is a very high-quality three-tier evaluation system. There is the Bureau, there is SAP, there is VEX, and all these three bodies are independent of each other, even though they work in the same direction.
I want to believe in this. Yes, I want to believe in this. Oleksandr, are you telling the truth?
Are you singing along?
You would for a minute.
Look, I'll tell you this in response to your question. 10% odds of acquittals. Specifically, well, if you take it like this, indeed, if there is the National Anti-Corruption Bureau, there is a specialized anti-corruption prosecutor's office, there is the High Anti-Corruption Court. Is there anywhere else? Well, in any field, such an example as you said, there isn't. So what does this indicate? It indicates that yes, we can, for example, convince the prosecutor, present some of our facts, that we see there is a crime. The prosecutor may agree with us or may not agree. Such facts often occur. They just aren't reflected in the format of an acquittal. But even if, for example, we reach the first instance, there is a key instance, there is the High Anti-Corruption Court, and even there is a first instance, a second instance, and a cassation instance. That is, this system allows for quite clear regulation of any issues that may cause doubt. So, as Ms. Olga said, there weren't such examples before, 10% acquittals, right? That's true. And we are aware of this.
Regarding statistics, I can add, I conducted my own research there. If you subtract the agreements and if you look at the complexity of the cases, the percentage is even higher. These are verdicts with agreements, where essentially the examination of the facts does not occur, is not verified. There are cases in the category of conditional bribery and the economic sector. Bribery cases are easier to prove because they involve lengthy discussions about direct evidence, video recordings, and the like. And precisely this percentage of acquittals in those complex cases where indirect evidence is used, where it is most challenging in terms of evidence collection and the judicial process. There is very interesting statistics, and if you delve deeper into it, you could even say that such a percentage is higher.
Yes, you see, the lawyer prepared and looked at the statistics of agreements. Out of these 240 verdicts, more. And by the way, I saw this when Judge Kravchuk spoke at the Criminal Law Forum. He provided statistics specifically on February 7th. So I used his statistics, 240 verdicts, 95 based on agreements. So indeed, if you subtract, it turns out to be a very large percentage.
Well, this actually indicates independence. Of whom? Could it be Vaksu?
Regarding the topic of possible pressure from public organizations and the media among ourselves, when we discuss this with colleagues, and we say that we counteract this pressure by reading the opposition Telegram channel to see what has been written. It depends on which news we are talking about. That is, we open some parallel information portal. Lawyers read it too. That's a joke. In reality, our work forces us to ensure that our reaction to such things, if we are talking about criticism, pressure, or influence, as we mentioned, should be limited to lunch breaks or coffee breaks. In our work, again, as Oleksandr says, we are guided solely by facts. Indeed, you can know something and be convinced of it, and some information, when it is contained in the media, can appear very convincing. But knowing and proving it are completely different things. And if detectives are less exposed to publicity, then the prosecutor bears all the negative publicity for the case. We are very often warned in those situations that are public, processed with broadcasts, and even every word we say in the case is dissected by professional lawyers and then turned against us. Therefore, we distinguish this element of our work for ourselves. If there is some informational message, whether it's criticism, a source of information, or an artificially created situation. And from work experience, we can understand this and accordingly understand how to react to this or that information. There are many cases where information from the media or public organizations serves as a basis for starting an investigation, because indeed there aren't many detectives and prosecutors, and it's impossible to cover everything. And there are many examples where, based on this information, a professional result is indeed achieved. There are situations and criticisms, and I see my position in such a way that if I cannot publicly explain my decision, then even I have problems with that decision. This philosophy can also be applied to this situation. If there is some public criticism that truly corresponds to reality, it is necessary to communicate. This can be done in some procedural form. If we are talking about a process, and in some very delicate and glaring situations, the internal policies of the body regarding public communication are implemented. Those situations where this communication truly needs to be at a public level can be seen on official pages. Sometimes it is not often published, but certain refutations of information may be published, with a dry reference to what is actually happening in the investigation, a dry reference to the evidence, a dry reference to procedural decisions, a dry reference to procedural results, and the corresponding court verdicts.
Yes, you see, but it's important when, for example, public organizations or anti-corruption activists help establish certain facts, which then lead to investigations. But we are talking about something a little different right now. We are talking about the fact that there is often manipulation of public opinion towards Viola, or information is presented in such a way that it is nothing but pressure on the court. I would like to provide examples. For instance, if you look, 60% of respondents believe that the pressure from public organizations is high or quite high. That is, material is already being presented, that next week a certain decision may be made by ISERI which will lead to this or that, or a certain judge has made a decision that portrays the judge in the most negative light in the eyes of the public. I think that this should not be the case. If NABU SAP, they are doing well adhering to the principles of correctness, business, and professional ethics, and conduct their communication, let's say, tolerantly and correctly, carefully, then yes, we cannot, it seems, impose. We cannot impose certain trends on public organizations, but there must be respect. Because then they say, why is there disrespect towards the court? Because this is tolerated. Not just tolerated, it is promoted, the disrespect towards our judicial system. And that's not right. Miss Olga, well, I'll give you a small answer right away.
For example, we encounter, indeed, as Mr. Andrii said, that in court the burden falls on the prosecutors, but it is clear that we accompany our proceedings, we observe the court sessions, and well, to be honest, sometimes the defense side, at a briefing after a particular preventive measure or directly in the court session, similarly, they say that the pretrial investigation body misled everyone. The pretrial investigation body falsified the facts. The pretrial investigation body did not obtain evidence. The pretrial investigation body illegally detained everyone. Speaking about correctness, yes, about correctness. Here, it's about the fact that if we face the truth, then...
The truth is somewhere in the middle.
The truth is somewhere in the middle. And quite often we hear, we as a law enforcement body, well, we can't somehow react to this when the defender...
Why can't you...
No, well, we do react, but I mean that it's a two-sided story. That is, we often encounter, and I think Andrii will confirm, when the defense side sometimes accuses the investigation body and the prosecution of some improper actions without proper evidence.
Have complaints been filed with the Qualification and Disciplinary Commission?
I am particularly interested in the opinion of the legal community. First and foremost, when in the premises of the court, the High Anti-Corruption Court, a representative of the legal profession, took possession of the court secretary's documents, and only through the intervention of NABU employees, who simply conducted an inspection and seized everything that was there, were these documents found among the belongings of this lawyer. And subsequently, we handed over these materials, registered a criminal proceeding with the prosecutor's office, and now it is in court. At the same time, there has been no response from the legal community nor reactions to the complaints for over a year now.
Well, this is a matter for the Qualification and Disciplinary...
Of course. You ask if we are responding. We are responding, but unfortunately, it is not working effectively. We have what we have.
I agree with all the participants in our discussion, but from the perspective of media and court communication and influence, I have always defended the position that the High Anti-Corruption Court, although it has the word anti-corruption in its name, the main word is court, which must operate on the principles of independence. And when a judge can change their opinion, their position solely based on public influence, media publications, well, perhaps I will express myself bluntly, maybe it's time to change professions. The court, regardless of what is happening around, must distance itself from any preferences, personal sympathies, and make decisions solely based on the outcome of the adversarial process and the submitted materials. And that is why it is very important. It is actually difficult. Because we live in such an information-saturated world where even if you don't want to hear anything about this case, you try to isolate yourself, but it won't work. You go online, you immediately read some ads, some publications, announcements will happen. In this context, when we can truly say that there is an attempt to influence the decision, these are the cases that Ms. Olga mentioned, where it's not just about covering the case materials, meaning the case is being reviewed, we are monitoring it, we will inform you. In such a context, this is, of course, very good. When the public is informed, not everyone knows, not everyone is interested. The cases are indeed all quite significant. This is acceptable. This is good. Personally, I lean towards the view that the judicial process itself is quite an orthodox process. But indeed, everyone knows, we conduct broadcasts on our YouTube channel. We allow press representatives when there are such requests. Very rarely, when it comes to specific issues, meetings are held in a closed session. But when such mainstream organizations or opinion leaders, as we call them today, actually indicate how tomorrow's session will take place, where Judge Petrenko will most likely try to dismiss a certain case, which will lead to the collapse of everything. This is unacceptable. The judge is likely not to pay attention to this. But such things need to be within limits, and any unpunished, let's call it evil, truly breeds disrespect for the court, disrespect for the law, disrespect for the work of law enforcement agencies, and even disrespect for the work of the legal profession. This is a process that must be within certain boundaries, and indeed there are already numerous cases where both investigative judges and appellate judges have appealed to the High Council of Justice not because they feel pressured or wonder, oh my, how will I handle this matter, but because there is a procedure, a legal procedure, including from the perspective of appealing to the High Council of Justice and the Prosecutor General. It's very simple. We can see that the amount of criticism, well, when the media appears regarding this or that decision, most likely indicates that there is no influence. The court did not succumb to influence when someone disagrees with this decision. By the way, not just anyone, but the same activists, those public organizations. So there is no pressure. There is indeed disagreement with the decision. To some extent, it can be within the framework, within the bounds of the law, within the bounds of ethics, or it may not be. Well, let's state that when a court decision coincides with public opinion, it is also not the result of influence, but rather the result of the process. Let's trust the court. I understand that it's difficult, maybe even amusing to some, but when we are building a certain democratic society based on the principles of the rule of law, we must respect the court, we must respect the law, and not subject it to such, let's say, unfounded criticism. And society must understand for itself that it should not succumb to perhaps such a revolutionary call. When we open the comments under such posts, what can we see there? It's not some public figure writing these comments, it's just ordinary people. That's it. This court, broken, corrupt. The prosecutor is not right. Detectives are almost fascists. Someone is writing this, these people are writing it. So, are they paying attention to such an opinion? When every activist, every public figure wants to criticize something, they must also think about the consequences, what public opinion they are shaping. What opinion people are being informed about regarding law enforcement agencies, about the courts? This is very important, in my opinion, and we need to respond to these things.
I thank you for these words. As a media representative, an editor of a legal publication, I would like to address my fellow journalists now. Our task is not just to convey information, but to help society understand complex legal processes, to separate facts from emotions, and understand how the system of anti-corruption bodies and justice functions. Only in this way can we form a responsible attitude among citizens towards the fight against corruption, which is based, I repeat, not on emotions, but on knowledge, reliable information, and critical thinking. Thank you for your attention. The independence of anti-corruption bodies from each other. We see such statistics. 75% overall indicate dependency. Over 48% of respondents indicate partial interdependence. A very interesting question for NABU and SAPO. Is there a risk that anti-corruption bodies, instead of doing their proper work, might influence each other? Is there such a risk in general?
Regarding this, I must say the following, in my opinion. The only parity in the system of anti-corruption infrastructure between NABU and SAPO is in procedural relations, unlike the similar situation in other law enforcement agencies. And what does this parity consist of? The fact is that during our work, and I think the defense side might have noticed this somewhere, in practice, both the detective and the prosecutor have their own positions. If the detective disagrees with the prosecutor's decision, we have a practice where he can appeal it. If the prosecutor disagrees with the detective's position, or if he believes that the detective is not working as he thinks he should, he responds to it. That is, we have both written responses and interactions in the format of working meetings. So there is no complete symbiosis between these two bodies. In other words, each body performs its own work. The pretrial investigation body investigates. The procedural supervisor directs me, but each has its own position and acts within its limits. Regarding the High Anti-Corruption Court, we have already provided statistics, and even the percentage of acquittals has increased, I think, from 10 to 18, which we will calculate a bit more now to reach European standards. If we consider, as I had the opportunity and experience to work in another system there was no such structure of relationships that truly corresponds to the criminal procedure code. Let's say it worked completely differently. In our systems, whenever someone hears about the anti-corruption infrastructure, they imagine two situations, or one, where everyone works together as a single entity. Although this does not reflect reality, because indeed the court operates as a court, the prosecutor as a prosecutor, and the detective as a detective. Sometimes someone sees them as opponents, competitors. This also does not reflect reality, because there is a legally provided quality procedural interaction. Where it is violated, where other formats arise, there is an immediate reaction, either from the bureau side, or from the prosecutor's side, or from the court side. As you just mentioned, Ms. Olga, you provided an example regarding the establishment of a fact of violating the presumption of innocence. In our relationships, in my opinion, this is a model for other law enforcement agencies on how to work, where the detective is not afraid of the prosecutor and can express his position. The prosecutor does not cover for the detective and reacts if the detective commits a violation. And including if these two instances make a mistake somewhere, there is a court that immediately gives its assessment, even if there is a mistake. The fact that there is sometimes a shared vision is normal.
Indeed, we have already talked a lot about the fact that there is no reason to speak of any dependency of the court or any, so why such statistics?
This is the perspective of the respondents. Let me remind you, the respondents are lawyers.
Perhaps these are the lawyers who were unlucky not to receive an acquittal. Of course, there is a certain procedural dependency between the prosecutor and the detective, since we really need to communicate and work as a team. A number of investigations, especially in certain categories of cases related to bribery, are very dynamic, and events unfold very quickly. And there, indeed, the prosecutor and the detective need to work as a team. But this is purely a procedural dependency. Of course, you understand that we have administrative separation. There are appropriate guarantees. The administrative independence of NABU, as well as the prosecutor's office, UMOSO, are separate bodies that function independently with all their internal procedures. Accordingly, we have developed certain internal documents that regulate interactions. This is a cooperation agreement, which also helps in certain situations to find mutual understanding. But first of all, it should be said that the main thing in this matter regarding the interaction between detectives and prosecutors is the understanding of each one's role. The institutions have existed for quite a long time. We have been functioning for more than 9 years. And I, for example, have something to compare it with. As I have been working from the very beginning, each institution is improving individually. Each is developing professionally. And these issues of relationships are also being improved. Such, perhaps, an unspoken understanding, at least in the situations I encounter, leads to the prosecutor being more responsible for legal issues, while the detective is more responsible for evidence matters. When we perceive the process in this way, everything essentially falls into place. The detective is a professional in gathering evidence. He knows where and how to obtain it, in what manner, and how to do it more effectively. The prosecutor can only guide in a certain direction, suggesting that a particular circumstance should be considered, and express their thoughts on the necessity of gathering more arguments in that direction. The prosecutor's responsibility is more about the legal assessment of the entire body of information and understanding the case's prospects up to the Supreme Court. We also clearly understand the stages of the process and the difference in standards of proof. At the moment, I basically don't have these problems. For example, at the beginning of the activity, there might have been different views among prosecutors and detectives, and some conflicts could have arisen. But currently, I don't observe this. For instance, however, of course, the cases are complex and extensive, and the issues we resolve are also quite challenging. And of course, we often have discussions. For example, Oleksandr and I still have some minor ongoing discussions about how to handle two cases. These are inevitable processes, of course, but we resolve these discussions. As they say, truth is born in discussion. So usually all issues are resolved in a working manner, and we find a common solution. But sometimes, of course, mechanisms for appealing decisions are also applied. There are cases when a detective appeals a prosecutor's decision. There are certain instances, perhaps of a prosecutor's appeal against disagreements with the actions of the DTP, but these are isolated. And yes, they are more exceptions than the general rule.
Adding to and supporting what Andrii says, indeed, a very key moment during our work, we found one of the effective ways of interaction, which is precisely the distribution of roles, because if you look at the criminal procedural code, it is written in a way that seems understandable, but it is assumed that quite broad powers are primarily given to the prosecutor as well as to the pretrial investigation bodies. And our effective interaction lies precisely in the fact that there are questions of fact and questions of law. Fact, evidence collection, that's the detectives. Questions of law, that's the prosecutor. There is just a certain compromise here where we recognize that the priority on matters of law lies with the prosecutor. And the prosecutor recognizes that how to collect and search for evidence lies with the detective. That's it. And this is not the interdependence, probably, that you were talking about. This is an algorithm for effective interaction.
44 respondents agreed to express their opinions in the professional block regarding issues of anti-corruption judiciary. 52 respondents, interestingly, are not ready to participate in this discussion, which indicates the complexity of the topic, or a cautiousness in expressions. So, all hope is on you, colleagues. The fourth slide, the application of agreements in corruption cases. What do we see? That the average score for the effectiveness of plea agreements is below average. Many lawyers believe that this mechanism is not effective enough and needs to be reviewed. And over 60% of respondents do not support the mandatory condition of exposing another person as part of the agreement. Andrii, do you see a whole trend towards excessive use of agreements in your practice?
I wouldn't use the word excessive. Let's still look at this institution from the perspective of the effectiveness of criminal proceedings. We are all currently discussing complex multi-episode, often economic cases. We can indeed somewhat extend beyond the cases of receiving or providing undue advantage, which are generally simpler. But when we talk about certain economic cases involving multiple jurisdictions, we understand that it is very difficult to investigate. We understand that it is very difficult to prove because everyone will agree that the line between ordinary business activity and a crime is very thin, and it requires very thorough proof in court. When there is still an opportunity to consider this case faster and more efficiently, what do I mean by efficiency? The goal, not just the punishment of the individual in these cases. We understand that there is individuality in punishment, that the person must be punished, that society must see that punishment has been carried out. But no less important is compensation. Because in these cases, it's about certain, or rather large amounts of money that are usually siphoned off from the budget. These are our funds, the taxpayers' money, society's funds, which could be directed towards other things. So, let's create a very simple balance for ourselves, but try to evaluate it somehow. What is more important? A person served 10 years, but hid all the assets they had siphoned off somewhere, and they are released after serving the sentence, but yes, they served the punishment, and we haven't recovered a single penny. We lost them forever. The person then gets out and uses them somewhere, for example, or another scenario, where a person makes a deal, helps with the investigation, exposes others, and compensates the state for damages. And recently, this trend has been increasing by transferring funds for the needs of the armed forces. This is a balance that needs to be examined in each case. Indeed, there won't be an effective deal when a person simply wants to avoid responsibility. And now, I just admit it. These are different things, different tools of criminal legal influence. When we talk about a classic deal, there should always be a public interest, in my opinion, and it should outweigh certain things like the fact that the person won't serve a colossal sentence That is, we have compensation, we have exposure, we have simplification. As a result, we also have a reduction in the workload of the pretrial investigation body and the court. This is a tool that is used in many countries. I can't say that it's excessive. Of course, there are certain problems with evaluating all agreements because we have a rather limited tool for appealing them by the circle of individuals. Usually, apart from the prosecutor and the defender, no one else has the right to appeal this agreement. Yes, there are cases where the interests of third parties are indeed affected, but these are very rare cases. Neither the appellate court nor the cassation court. It cannot provide an assessment, essentially. In this case, the role of the court of first instance is very important, as it must truly verify how such an agreement will align with the interests of society. I believe that they should be applied. Currently, we have legislative changes that have more or less already organized these issues. Before this, in general, from the perspective of us all being professional lawyers, there were certain discussions regarding the application of Article 75. That is, it is written in the criminal code in such a way that opinions among all lawyers were almost split. 50-50 on whether the conditional release can be applied. In criminal cases, exclusively based on an agreement, or this norm is categorically prohibited from being applied. And again, over the years, as we have applied these agreements, we have not been able to obtain a position from the Supreme Court for one simple reason. Because these cases did not reach the Supreme Court. We had positions from certain individual judges of the Supreme Court, and they, by the way, also differed. But everyone said that in order for us to provide you with some guidance, both for the pretrial investigation body and for the court, the case must reach us. We will provide evaluations. We will guide you. Finally, we now have not just a certain but a specific guideline that told us that agreements can be made with the condition of no actual punishment, and there is significantly increased financial liability imposed on individuals, which is truly aimed at compensating for damages. My personal opinion, from a financial perspective, as far as I remember, is that those individuals who commit these crimes are pursued. This is enrichment. In other words, the goal is to obtain some money. And when committing these crimes ceases to be economically beneficial, then we can say that this will reduce the number of such crimes. In other words, we need to make them not just punishable, but we need to make people think about the sense of getting some reward now, when you will pay many times more. And I am sure that this will be more interesting for both the state and society.
I completely share this opinion. As a practicing lawyer, from the perspective of prioritizing the client's interests, I believe this is one of the most effective mechanisms. In general, what is an agreement? An agreement is the material and immaterial benefits that the state receives and your client receives from the state as a result of a certain procedural compromise. What does the state receive and what does your client receive? Well, firstly, the state receives the achievement of the objectives of the criminal proceedings. What Andrii Serhiovich mentioned, there are cases that we have been hearing for 5 to 6 years, and not because the court is slow in hearing and reviewing cases, but due to the large number of participants, multiple episodes, and transnational investigations. It's all difficult. When a verdict is issued based on an agreement, the court does not evaluate the evidence. This is a very big time saver. It saves state resources because the prosecution, the prosecutor, detectives, they are already there. As an agreement can be made at the pre-trial investigation stage, or it can be at the trial investigation stage. This saves the time involved, which the state spends on investigating these cases, paying salaries. Currently, one of the main requirements, and what we see, is that the legal profession, well, it's clear why the legal profession is against it, is obtaining incriminating testimonies. And in principle, this is a requirement and a trend, the main trend. Now, apart from compensation, the latest trend is on the side, because if the prosecution does not want to make a deal, nothing will happen. There are 2 criteria. First, if it's about economic crimes, compensation, from full or partial. And they definitely ask for exposure. It's not just that you gave testimony incriminating yourself, but they also ask for exposure of other crimes. This, I say, is what we have from practice. Another interesting trend that I see now is that if we take the private sector, let's call them businessmen. As they say, the prosecution side, they normally agree to make a deal, which aligns with their interests. However, if it is the public sector, if these are top officials, ministers, not the public sector, I repeat, then currently the prosecution takes the position that such individuals must necessarily serve a sentence. Actually serve a sentence. Therefore, an agreement might even be considered, also based on practice, but with the mandatory serving of a sentence involving deprivation of enemies. That is another element. Besides the agreement is the latest trend initiated by both the prosecution and the High Anti-Corruption Court. Our state budget is replenished with significant amounts of money because the agreement, among other things, is about public interest and usually involves transferring funds to the armed forces account or the bail that the person has posted. If it was posted by guarantors, then according to the guarantors' statements, that is, besides exposure and repentance, there must be public interest. And public interest involves exposure and providing incriminating testimony. And this directly involves compensation for damages and transferring funds to the armed forces. By the way, I want to advertise the High Anti-Corruption Court. At the same time, I'll advertise myself by saying that I read the monograph released for the 5-year anniversary of the High Anti-Corruption Court's activities. Joking aside, the issue of public interest is very intriguing. It is not regulated in the code what constitutes public interest. This criterion does not exist. It is very interesting how Vera Volodymyryevna Mikhailenko elaborated in her monograph on what agreements are and what public interest in agreements means. Therefore, the conclusion is that it is maximally effective. If there is an opportunity, one should use this mechanism.
It's nice to see that in this part our thoughts coincide. As a representative of the investigative body, among other things, I can also point out that if we are indeed talking about a complex, large economic case, and especially when we have foreign jurisdictions involved, as a rule, top officials are always engaged in it. There are usually not many of them, 1 or 2 lower tier. These are high-ranking officials, but not the top ones, and a multitude of various employees down to the lowest level. Similarly, there are people who help, for example, to legalize these funds that are transferred through various companies. And thus, if you bring everyone to criminal responsibility, it could be 10, 15, or even more people. And from the practice that has developed, hearing such criminal cases is difficult. But the most interesting thing is that if, for example, the head of some technical department, while preparing technical documentation for a tender, received some benefit and instructions from their superior, then in fact, bringing them to criminal responsibility and subsequent imprisonment is unlikely to significantly affect the overall crime situation. And indeed, this is a position that I fully share. When people who are at the lower levels participated in criminal activities, having compensated and fulfilled all necessary conditions, they can, let's say, conclude this process quite quickly. And as for the top official, without whom this entire system wouldn't have worked, I am convinced that they must be held accountable specifically in court. But if out of 15 people only 2 or 3 remain, then this is a significantly different path. It is much faster and much easier from the perspective of proving, because when we prove each participant's guilt, it is easier for the investigative body and accordingly for the prosecutor when people confess and expose. And for us, such an important element is not just the testimony. That is, when we talk about exposure, it is a complete set of actions that allows us to ensure that this exposure is real and justified. Because when a person just says that someone did something, we are very critical of this, only indirect. And other evidence that proves the fact that these testimonies are true are taken into account when the prosecutor makes a decision regarding the appropriateness or inappropriateness of concluding an agreement. And we accordingly work to ensure that the materials we provide to the prosecutor are as thoroughly prepared as possible. For example, we have interesting cases where the amount of damage caused is sometimes exceeded several times over. As a result of compensation, when there are, for example, 5-8 suspects, each of them exposes another suspect and compensates for the damages caused. And it happens that as a result, the state receives 2 to 3 times more. And the key figures, they go to court and their involvement is actually considered. And then a decision is made on whether they are guilty or not guilty.
Indeed, I support all the colleagues who have spoken from the prosecutor's point of view. Of course, this institution of agreements should increase the number of such cases as they are applied. And there are certain statistics from abroad. For example, in the USA, they say that about 95% of cases may involve agreements.
And we have 12%.
Well, the survey was conducted not so long ago. It might not cover the legislative changes that have occurred recently, let's say new practices with the new legislation. They are only now, it is being formed, and let's say the effectiveness of this institution can change very quickly and in the near future. Because what we had under the old legislation, this is what Oleksandr was talking about. When we have a case that is complex, organized crime, there may be several, up to a dozen accused. Even when someone wanted to cooperate, they couldn't do it simply because there wasn't, well, some kind of adequate legislative mechanism. So what could such an accomplice who wanted to cooperate receive? He could receive the same punishment under the agreement that he might get if his guilt is proven after 10 years of trial, 8 years of imprisonment. You can get it now, or as a result of the trial in 10 years. Well, obviously there's no need to rush for that. Therefore, of course, here you could say hands were tied. There was also indeed a discussion about the possibility of applying suspended sentences. This was also a very pressing issue, and it became particularly acute for the prosecutor, given the situation where one case, such publicity it was, where the prosecutor was held accountable for disciplinary action because the court approved an agreement with a suspended sentence in a corruption case. This verdict was not overturned, it remained in force, but the prosecutor was subjected to disciplinary action. Did he appeal? He did appeal, yes. He went through these instances, and yet the decision remained, and this somewhat tied the prosecutor's hands. There have been very heated discussions about the new law. They were public, and it has been adopted. It truly provides many mechanisms for how such agreements can be implemented. From the prosecutor's point of view, there are real mechanisms, and not only for the prosecutor, but also for the defense. That situation, 8 years, now either C or D or in 10, it will really make sense. Therefore, indeed, it might make sense to conduct such a survey in 6 months or a year.
When will the new legislation be in effect? But right after you. We will now, as late as it is, conduct another survey in the High Anti-Corruption Court and in NABU and in SAPO. And then we will see how do your colleagues perceive the effectiveness of this mechanism?
You know, it seems to me that this percentage, 67% of those who critically perceive the application of agreements,
maybe they haven't made any, well, you know.
We currently have a trend where lawyers are more proactive in initiating agreements rather than the opposite. That's how it is. As it becomes a trend, they often disguise themselves to the specialized anti-corruption prosecutor's office, and then, in principle, they quite often reach a consensus. Perhaps it's just the number of those who were refused.
The number that did not apply, and does not know that it is quite effective.
Because it is actually a very convenient mechanism for everyone. For the investigative body, we spend fewer resources. For the prosecutor, the case is reviewed faster. For the court, now, the procedure is more convenient. And for the defense side, it's a situation where you can provide your client with a much quicker outcome and achieve the result they expect. Well, unless perhaps someone wants to deliberate for quite a long time.
I would like to make a small disclaimer after this segment of ours, because it might create the impression for those who will watch this, that we are advocating, let's make deals, let's release everyone through deals. Yes, it's simple, but always keep in mind that each case is individual. And indeed, there are cases where a deal will be effective. And there are cases where it will truly be, let's say, legally incorrect. Therefore, each case is individual, each case is considered individually, and decisions regarding each person are also made individually.
And here's another point. I just want to highlight that the discussion also involved, as far as I understood, the moment of mandatory disclosure that stirred the legal community.
Yes, that's the point. Of course, the legal profession dreams that this element would not be misunderstood. For reasons, and I support this, it would be much easier, Marcos, and better if the party does not want to accuse.
The beginning of Article 63 of the Constitution and the agreement.
Well, almost just a little bit off.
Minimum punishment.
A little bit off. Well, we have to dream of ideal constructs.
Well, you know, if we recall James Comey's higher loyalty, the FBI had a principle where disclosure was not limited to just the episode in question. A mandatory requirement to disclose all episodes of criminal activity. If a person did not disclose something and it was later discovered, the agreement was cancelled.
We need to provide these examples, I ask you. There is no need to provide grounds for additional changes. Let's at least stop at this.
Regarding the individuality of each situation, we have already talked about the fact that the number of detectives is not unlimited, the number of prosecutors, and the amount of court working time. And there may be very minor cases that, just because they are compared to others, their social danger is not so significant. They might not be worth the whole long process. There are cases where very important issues are resolved, and the stakes of these cases are very high, and it may not really be directed in the public interest to. This case was heard in great detail. In the United Kingdom, as far as I know, the concept of public interest is very interesting. Works there, even in the presence of signs of a crime, the prosecutor can decide in certain cases not to send the case to court, and this is his discretion. Some minor hooliganism, some petty thefts committed by individuals from vulnerable social groups, even when these situations occur, all signs of a crime, a decision can be made to send the case to court. And of course, the issue of agreements is very multifaceted and complex, because cases are completely different. Perhaps for each case, a huge state resource needs to be spent. There is even a thesis that fighting corruption is worth it up to the point where the effect one of such a fight exceeds the costs of this fight.
Probably the key element is about justice. Because when it comes to a top official, obviously the public interest is that they receive fair punishment.
And who determines? Who determines that it is in the public interest for them? For example, to actually serve the punishment.
We have a public demand for those people who directly build schemes, who create such conditions. When the country, the people, lose entire enterprises, sectors of the economy, these people must be held accountable. It's one thing when a large number of small workers, or cogs as they are called, are involved, and whether there is a need to hold them accountable. But those who are at the top and organize this entire machine, thereby sometimes destroying an entire sector of the economy, large enterprises, let's say, what are we coming to? That the executors change, but those at the top, those who organize these processes, they are not always sorry for them. At the same time, when we achieve the goal and can deprive those at the top who organize all these processes of the opportunity to do so, and in the future, if we have done our job well and provided proper evidence of their involvement, they receive a fair sentence. So somewhere probably here lies this balance of justice.
Are there cases where the bail amount clearly does not match the severity of the charges? Of course there are. Spoiler, there is a low level of trust here. Many lawyers point out the discrepancy between the bail amount and the severity of the offenses. Question to Mr. Andrii. Explain how the bail amount is determined, and whether there are cases where it clearly does not match the severity of the crime.
This issue is no less controversial than the issue with agreements. I will try to condense all of this into a single point. The regulatory framework, the issue of determining bail, in my opinion, is not a current one. It is very simno outdated, because Article 182 of the Criminal Jurisdiction Code, which introduced the possibility of such a means of securing criminal proceedings as bail, has not been changed. It does not take into account the specifics of corruption cases, nor does it consider the harm that is indeed caused possibly by these crimes that we are examining. And the amounts that, let's say, the legislator set in 2012, which currently for serious crimes, as far as I remember, is 242,000, and for particularly serious ones, 908,000, do not always correspond to the common danger. My position in terms of bail is that it should not be a kind of buyout from the proceedings. That is, when we determine the amount of bail, it should not be such that a person thinks, phew, I have this amount now I've paid and I can just go somewhere. That is, indeed, this amount should deter a person from certain actions. And it is very difficult, again, let's pay attention to how our culture is developed, of declaration, income, assets. That is, usually we can see in the materials of a criminal proceeding regarding a certain person when we refer to the declarations that justify the request for a preventive measure. There is nothing. The income is small. Real estate is absent, or there is some small property registered to some close relatives, and vehicles are also absent. Based on the criteria for justifying existing assets, it is obvious, perhaps, when we focus solely on the issue of declaration, that any bail exceeding the amount of these assets will be perceived as unfair. But let's pay attention. Even at the beginning of VAXU's activities in 2019, well, yes, the amounts of bail were increasing. And what is characteristic? They are being paid, and it is often said that, very often in the appellate process, decisions regarding the application of already paid bail are reviewed. And one of the main arguments is its excessiveness. Yes, well, we cannot restrict any person from proving their position, limit them with certain arguments. Well, can we discuss the issue of the excessiveness of bail that has already been paid, in fact deposited, and is large, and does not correspond to the person's means? And there are indeed cases when it is determined the sufficiency or the large ball amount of bail and its size. The person does not pay it. There are cases when the person is in conditions of isolation and does not pay. Here, the court uses the practice of the ECHR and gradually reduces this amount. And again, we can see a trend. In such a case, when the amount of bail is gradually reduced, it is eventually paid. Determining the amount of bail is a multifaceted issue that must be examined in each individual case, taking into account both the materials and what the judge perceives during the process. I do not agree with the position of certain colleagues, but I have seen such reasoning several times, where they even point out, look, you have such lawyers. You have such lawyers, they are so serious. We understand that you pay them huge amounts of money and you claim that you have no money. This is unacceptable. Definitely. But this also indicates that there are no such criteria. If we were in a society where everyone declared everything, it would be much simpler. We could have an idea of what funds a person has, what funds are truly significant for them to refrain from certain actions. This is not available, and it's almost always like this, intuitively. Therefore, this is a very complex issue.
I am here. I am listening to Mr. Andrii and immediately recall one of the court sessions we observed, and the official income of the person was relatively insignificant. We proved that the person has the means and assets. We prepared a motion and the prosecutor agreed. If I recall correctly, 300 million hryvnias we requested as a bail. The entire court session, the defense argued that this amount was excessive, impossible, and it was impossible to pay, so they requested to reduce it to either 5 or 7 million. And we had a record. The court said 270 million, as far as I remember, a bit more bail, and it was paid in 45 minutes. This is exactly about the fact that as we prepare, of course, we justify there is such a thing as the ultimate beneficial owner. That is, when a person de facto, de jure, more precisely, is not the owner of certain assets, but de facto through controlled persons owns and manages the respective assets. However, what surprised me the most in this slide was that, as I understood, the defense side was struggling over the small bails. Right? I understood correctly, yes.
What was upsetting was that the amounts were too small, allowing suspects to easily avoid imprisonment. There was something like that.
Yes, I noticed that uncharacteristic for the defense side simply because, as I understood, it was the lawyers who were the respondents.
We, on the contrary, always say that the amounts are excessively large, disproportionate.
But a higher percentage indicates the mismatch in size.
Overestimated, yes. And in our case too. In the absolute majority, practice shows that when we have to, and we manage to prove that a person indeed has the relevant assets, a decision is made for the appropriate bail, and they are paid. Indeed, the amount of bail paid is sometimes tens or even more times irrelevant to the income and financial capabilities of the suspect. That is to say, the point is that indeed, the system of income declaration and accounting, at the moment, it is far from perfect. And it's good when the court takes into account the objective data provided by the prosecution so that this bail is objective and truly motivates the suspect not to violate obligations. Because essentially, why is bail posted? Its key purpose is to ensure that the suspect fulfills the obligations imposed by the court. We have examples where I don't remember if it was 80 or 90 million UAH that was collected into the budget due to non-fulfillment of obligations, which indicates that in these situations, obviously, this amount was too small.
Olga, I have a question for you. May I? Yes. Have you encountered in your practice cases where bails become tools for bargaining in court proceedings?
I have a positivist approach. Let's do it this way. First, statistics. Statistics show that out of 302 motions over 5 years, which were filed for the selection of preventive measures, 265. The preventive measure, the chosen, was specifically in the form of bail. As a practicing lawyer, I always ask judges the question, why do you choose? A trend. So the statistics, 302 motions, 265 times bail. Trends, tendencies are chosen. In 90% of cases now is detention with the alternative of posting, bail. And I always had the question, why choose detention instead of just bail? This is precisely an element of a kind of bargaining. Because when a person is detained, it encourages them more to pay the bail. If we look at it from this angle, then maybe yes. On the other hand, in principle, there is no other side. If a person is detained, they are detained, and they look for mechanisms to pay. What Andrii Serhijovich was talking about is true. The code defines the upper limit, these 242,000 hryvnias or 908,000. In practice, these bails are always higher. I understand why I support this. Because in cases under the jurisdiction of the High Anti-Corruption Court, there is no alternative to detention. If in other jurisdictions, in other cases, there are cases where only detention can be applied without the alternative of bail. So this bail serves as a kind of balance, a compromise, so that the person is not held in custody but pays the bail. For me as a practicing lawyer, it has always been interesting, this mystery, the mystery of determining the amount of bail. It is truly a mystery. It's a mystery. I searched for answers to this question. I almost found them. And all those monographs dedicated to the 5-year activity of the HACC, they say that these should be taken into account. Circumstances of the criminal proceedings, the special nature, the suspect, their financial status, financial operations, as Andrii Serhijovich mentioned, data about the person, data about their financial status, their relatives. Sometimes there are relatives who require special care and there aren't many funds available. That is, this issue, bail should not be excessive. To avoid these elements of bargaining, bail should not be excessive. And on a positive note, I like to end everything on a positive note. HACC and NABU. They have demonstrated a mega-progressive approach in terms of bail. And when the full-scale invasion began, it was the SAP and HACC that initiated this practice, transferring bail to the account for the armed forces. This was a practice of the HACC. And don't know the amount, but it was something, a fantastic amount was paid thanks to the activities of the SAP and HACC to the account of the armed forces. I remember in the first days, literally a week had passed, I remember a call about, the prosecutor says, Olga Viktorovna, how do you feel about talking to your clients, the defendants, to reduce the bail amount by transferring it to the account of the armed forces of Ukraine? And this is a progressive approach. From a progressive and also complementary point of view, DOSAP and VAX, this is what VAX has demonstrated, great independence from a political bias and B, there are such control cases or directives from above. How do other courts demonstrate this, for example? I will give an example of a progressive approach. Everything becomes very clear with an example. There was a client, illegal enrichment. This is not a serious crime, not a mega resonance. It was investigated by the State Bureau of Investigation. The most fair Peshchsk district court in this world was chosen. A preventive measure was chosen. Illegal enrichment. There was about 40 million. A preventive measure of 300 million UAH was chosen. The person says, I don't have 300 million UAH. He is held in custody. Another month, the question of changing the preventive measure arises. The State Bureau of Investigation transfers the case to the National Anti-Corruption Bureau and the Specialized Anti-Corruption Prosecutor's Office due to jurisdiction. Meanwhile, the lawyers appeal to the Pekers Court, arguing that the bail is excessive and citing health issues because the person indeed has diabetes that needs treatment and there is no proper approach to treatment. We got involved in the case. Just to give an example, we begin to consider the issue of changing the preventive measure. I call the SAP prosecutor and say, look, I'm always straightforward. We found guarantors for 15 million UH. The amount of illegal enrichment is 40 million. We found for 15 million. I declare that we are ready, together with the guarantors. If the court chooses a preventive measure of 15 million, we are immediately ready to file a motion to reduce and transfer to the armed forces of Ukraine. I propose a procedural compromise. What is better for the state? When a person is held in custody, it's not a violent crime. Even the social danger of this crime is not such that it warrants a person being held in custody for so long. What will be more beneficial for the state? Transferring 10 million is a significant amount. Now, for the armed forces of Ukraine, when the state needs it, we commit to fulfilling procedural duties. Prosecutor of the State Bureau of Investigation, I heard your position. We have submitted an official letter for the case to be considered in the High Anti-Corruption Court. I stand up and state the same position, Your Honor. Here I declare that I proposed officially addressed a letter to the Specialized Anti-Corruption Prosecutor's Office. And I inform the court that we have collected such an amount. We are ready to contribute 15 million UAH together with the guarantors. We declare, I as the defense guarantee to keep our word and procedural behavior. We are ready to pay 10 million for this. The court chose 15 million detention with 15 million as an alternative bail. And as we promised, accordingly, immediately after paying this bail, the very next day we filed a motion to transfer 10 million to the court. In another similar case, 400 million is also incriminated to the client. Illegal enrichment, SBI Peshchsk Court. For the third time, the person is trying to somehow reduce it, but nothing works. That's why we are talking about bail, about a procedural compromise. We are talking about guarantees because it is a political case there. Therefore, I want to say thank you personally, and perhaps on behalf of the legal profession, for the fact that the HACC still demonstrates complete independence from political pressure, directives from above, and commissioned cases just like NABU and SAP. Here, I also consider them leaders in terms of steadfastness in this situation. That's my insight as a practicing lawyer.
So let's move on to the sixth slide. Proportionality of punishment in corruption cases. What do we see here? Over 41% of respondents believe that imprisonment is inappropriate in most corruption cases. The main alternative is fines and bans on holding certain positions. Key comments from respondents emphasize the need for effective enforcement of fines, as they often remain merely a formality. I want to, now that you have asked the question,
I'm all for it. I believe that fines are the most compromise option in terms of when a person should be held accountable financially, so that they are graduated according to the severity of the crime committed and the severity of the punishment. In my personal opinion, it should be this way. Because 2 words. I understand the prosecution side, meaning I understand the public demand. I understand everything, but society also needs to understand, and when it doesn't find itself in such a situation, it sees things differently. But when you see through the eyes of the clients and see any criminal proceedings, what is the purpose? No, of criminal justice. It is for the person to be rehabilitated, to serve their punishment, and to be rehabilitated. From the moment the notice of suspicion is announced, the person is already under stress. The notice of suspicion is served, preventive measures are chosen, procedural coercive measures are applied, such as asset seizure, relatives are worried. you are anxious, and there are endless court hearings. So what does the state gain if, yes, I understand the demand, I understand, as you say, the demand for the person to face justice. But where is the boundary of that justice?
The people elect individuals to become members of parliament, and then the government and all state institutions are formed. And when someone is entrusted with top-level trust, that is, for making various decisions, and a huge number of directly and indirectly subordinate people depend on this person, and when this person betrays that trust,
then let them pay the state 3 times more than what they betrayed. And what about him? The state will spend money on him.
But look, there is such a thing as prevention. Will it have a preventive effect in this case? Well, fine, everyone will know that. If I am in a top position, someone has entrusted me, well, let's say, has treated me with top-level trust. Here too, let's face the truth. When we hold someone accountable and prove 1 episode or 2 episodes, it is a meticulous, hard, complex work. But there are a lot of hidden action that have taken place and episodes that perhaps the investigative bodies have not established, and funds that have been transferred abroad.
All right, look, I really like Andrii Serhiyovich. Today, our thoughts have aligned, you know. I really like the point that Andrii Serhiyovich made. All right, a person served 10 years, caused damage worth 5 to 10 billion hryvnias, did not compensate anything. And what did it make it any easier for you as the prosecution?
Look, there's a very important point here that we are not talking about everyone. We are talking about the top. But here we are talking about everyone.
In this survey, we are talking about everyone, not just the top.
We have already discussed before that, in general, everyone agreed that a large number of people involved in joint activities, well, various performers are quite okay. When they make a deal, pay some compensation, pay a fine, it's normal. But when we talk about the direct organizers, about people who consciously create conditions, circumstances, corrupt a large number of people, and then allow them to simply avoid, let's say, avoid all consequences in the form of just being scared by a fine, it seems to me that this will disrupt the balance. Let's say, this is a personal opinion.
There is a theoretical question regarding this. I have already expressed my position. Can we talk about a big scare when a person potentially acquired indeed 10 billion dough and the fine they have to pay is 20 billion? And this is more than they have. And won't it be a deterrent factor for a person who he will now be left to, without money, his family will be left. Without money, his children will be left. We are not even talking about reputational losses. That is, I'm not saying, when I mentioned the thesis about punishment, I'm not saying to completely replace it. But still, perhaps today we are applying the punishments that we have in the law in any case. Whether they are liked or not, they exist, they are prescribed, there are tools that we cannot apply in corruption cases. But still, I tend to think that this is a general thesis, how to implement it in practice. Honestly, we will not determine within this discourse, but a corruption crime must cease to be profitable.
And knowing the mentality of our people, it will indeed have the most significant preventive character to prevent committing other crimes.
But there is also that factor, nah? Let's remember how the competitions in NABU, SAP, and HACC started. That is, when they began to determine the remuneration for work at a more or less decent level. Let's recall the salaries that judges had, for example, 10 years ago. The standard of living, which was constantly increasing. We understand that it is very difficult for a person, and the same applies to all state officials. We understand that the salary level of top officials, except for certain state-owned joint stock companies, is not very high. It is not very high, and such a level of personal remuneration, well, it is also a certain factor, considering one's salary, reputation, and that suitcase of money that one might gradually somehow extract. It's a very multifaceted issue.
Indeed, there was a discussion raised that in those conditions, if we say that there is a lot of shadow economy, many undeclared assets, and the real lifestyle of individuals involved in corruption significantly exceeds their official income, then the fine might simply be seen as an attempt to buy one's way out. And indeed, this is a complex, multifaceted issue.
Yes, and one could also say that a bribe is an attempt to buy one's way out.
We can analyze each specific case even to the extent that, based on the circumstances of the act, we can see whether the person is involved in some systematic activity, or if it is just an individual case where they might have stumbled on or been tempted in a particular situation. Because even the same qualification, the same crime, but you see that they obtain undue benefits through such complex schemes that have been developed over the years, and people definitely worked on and thought about them. And this really indicates some kind of systematic activity, or whether it is truly an individual case where a person, well, just had such life circumstances. And this should also influence and be taken into account when imposing these punishments. Therefore, when we talk about grand corruption, about large-scale embezzlement, it is very difficult to find this balance between public interest and general prevention. We must be convinced that the fine will not ensure that such schemes will not continue to exist, that this person will not continue to engage in this. In the future, there are global examples that suggest that such less severe punishments like fines work more effectively in countries where public disapproval has an impact, such an effect, where the loss of reputation can cost a person a lot. There, indeed, a fine can be sufficient, and it can be considered as a basis. In some cases, even for a millionaire, community service might have a greater impact.
I thank you for this fruitful discussion. I hope it benefits our viewers and that everyone will draw their own conclusions. I ask everyone to subscribe to the YouTube channel of the legal newspaper to not miss new discussions and interesting projects, and also to definitely leave a comment, and our guests will respond if there are questions. And we are not saying goodbye until we meet again.